Five. My senior is due to some personal difficulty could not attend. They may have it after 2 weeks.
Arjun,
HRH Chaudhary. Number 5. Yes.
Arjun.
Lordship, by taking consent from the other side, I like to mention item number 16 of today's daily list. So Lordship may kindly grant 3 weeks time. My senior is having some personal difficulties.
Arjun.
Much obliged.
May I please, Madam, with the consent of the other side, Madam, I'd like to mention item number 28 and 29, Madam. We are late by, Madam. Senior Counsel, you as a Madam. Can it adjourn for the, he has some personal difficulty today, Madam?
Arjun.
Yes, Madam. Can it be fixed on 2nd of April? He's on outstation council, Madam.
2nd of
April, Madam.
2nd of April is not possible. There are too many cases we have already fixed.
No, did maybe
Any
fix
date
it
in
for
the May,
8th of May?
8th of May.
But can it be
9th of May.
Can it be on the month of April, Madam?
9th of May.
I'm obliged.
Well, I beg to measure item 34, my lord. My lord, in this case, my lord, some mistake is there on my part, my lord. I want to withdraw this appeal, my lord, with a liberty to file a fresh, my lord.
What's the mistake?
My lord, a ground has been taken, which is against me, my lord.
That's good. It would help us. If you have already taken a
Inadvertently that was
against
taken,
you,
my
that would help
So,
us.
I'll refile it, my lord.
In concept of the plant has submitted that due to some inadvertence in the pleadings, he wants to withdraw this writ appeal with liberty to file fresh. Dismiss with liberty as prayed for.
Obliged, my lord.
Yeah, the lordships, my lord, I have the prayer to consider bench, my lord, for review petition comprising my lord Justice Pathak and my lord Justice Thakuria. It may be considered on.
That is not to be mentioned here. You make a request to the registry will put before me, then only I'll pass an order. There is no question of why you are making this request in the court itself.
Constitution of bench
You move and
registry.
move an application before the registry.
For pronouncement of judgment, item 32 and 33.
Both the inter-court appeal dismissed.
Daily list for orders item 1.
Here, Malad, in respect of inspection, in respect of 2 jails are still remaining. Malad, the committee constituted by the Honorable Court.
Nominated new member.
Malad, the DIG Jorhat, he retired and the new incumbent has joined yesterday. So
You have already nominated new member.
New member has been nominated. Malad, the new person has joined the office, he will be inducted in that committee. Malad.
What about the Arunachal Pradesh and Mizoram, Nagaland, Arunachal Pradesh?
Arunachal, madam, the reports have been received, madam. In a day or two, we can finally.
And what about regular states, Mizoram and Nagaland? When?
Yesterday.
You have already filed. And what about? Okay, okay.
But so far as Mizoram is concerned, my lord, I think. They have filed their affidavit. I have seen their affidavit, my lord. Perhaps this aspect, this is with regard to overcrowding in prison. A news report has come that pursuant to an assembly query, that there is huge, they have to perhaps incorporate the details.
Where's
My lord, I'm sorry, my lord, it's small, it's all prisons in Mizoram,
overcrowding.
yes.
This is recent report.
A recent,
Recent, Lordship.
recent thing, day before yesterday, it came in the,
So they already filed their response.
No, Lordship, regarding this not. Lordship.
regarding
Otherwise,
this
I
not
have-
filed.
have
Perhaps
filed,
they have two, my lord.
Then what,
Further instruction I have
no,
taken,
you filed your response day before yesterday.
yes,
So what do you have mentioned in your response?
no.
Nothing.
They have simply said that there is no,
They haven't gone into that aspect of the matter. They haven't,
this is the core matter here.
yes.
So I have to incorporate this and Lordship, I have to take instruction regarding this Lordship. Just now I have come to know Lordship regarding this news item Lordship.
In fact, the writ petition is registered only taking into consideration that all the jails are in the northeast or in the all over the India are overcrowded. And if you have not addressed that issue in your
Lordship,
counter,
that is already,
what counter you have filed?
Lordship, that is already Lordship expressed in our affidavit Lordship. Earlier affidavit we have expressed Lordship, report of compliance Lordship that is.
So, as per that affidavit,
Yes.
whether it is those jails in the Mizoram are overcrowded or not?
That is not in my affidavit shows that not Lordship, but that is the recent Lordship, day before yesterday that is published Lordship. That news item Lordship. So on that news item, I have to take instruction Lordship. Just now I have come to know this about this item.
Mr. Das,
I'm sorry, my
you do one thing,
lordship,
well, counter to their whatever the affidavit they have filed
lordships,
and incorporate this thing in.
lordships.
If they have, in their affidavit, they have stated that those are not overcrowded, then we'll consider.
Fine, my lord, fine.
File your.
Yes.
You can file a report on.
I can file the report, yes, my lord, as an amicus curiae report.
DK. Mr. DK Sharma. Mr. Nath. HK Nath.
Government.
Some. Mr. D. Nath. Then Council of Learned Senior Government Advocate Assam has submitted that in place of the retired member, a new member has joined yesterday only. Therefore, some time may be granted. File latest progress report, the matter. Stop. Learned Council preparing for the state of Mizoram has submitted that they have already filed. The state of Mizoram and Nagaland has submitted that they have already filed their response to the writ petition. The registry is directed to place the same on record. Learned Council appearing for the state of Arunachal Pradesh raise a week's time to file a response on behalf of the state of Arunachal Pradesh. Time period for is granted. This matter On 2nd of April 2024, in the meantime, Mr. Amicus Curie, Mr. Das may submit a state, may file a submission in respect of the responses filed by the respective states.
Fine.
May I pray, Lordship? Lordship, kindly change the date. 2nd of April, I will be out of station, Lordship. Any other date except 2nd of April, 1st or 2nd. After 2nd of
8th of April.
oblige. Lordship.
8th of April. Fine. Deeply.
Item number 2,
Yes, what are your instructions about the appointment?
My lord, it is pending in the
Why
finance.
it is so pending, spending seems
My lord, some views of the judicial department has been sought for.
the court order means they have taken time for the point. So this is the modality to follow. You order to you order compulsory like review and okay, Mr. Barpujari,
My lord,
this mechanism of SLC being the final authority to recommend,
absolutely,
that is devised as per the judgment in the case of Achut.
absolutely.
Yes.
Subsequently, my lord, reaffirmed it further on Nessa.
Now, therefore, this is a mechanism established by judicial order, which
Absolutely,
says that this will be final,
absolutely,
subject to judicial review.
absolutely.
Now, can the SLC's order be reviewed by the finance department? SLC is headed by the chief secretary.
Yes,
And if not, where is the scope of legal opinion? That's what we are
yes,
asking. you.
yes, yes.
Are you not trying to reverse the finding of the learned single judge affirmed by the division bench?
Yes,
Plus, there is already an order here.
yes. In fact, my lord, in the SLC, my lord, the representative of the finance department was also there.
But who prevented you? Why you are seeking this opinion from the judicial department and AG and all?
My lord, they say,
But you are avoiding the order of the court. We are constrained to call the finance secretary.
lordship may pass a
Are you
direction.
ready for that?
This is a direction, that's what I was asking. 21/11/22 order is a direction.
To consider her case, and after consideration, you have decided to give her appointment. And now you are saying that we'll seek opinion by?
The reason, my lord, that is not disclosed, my lord. Otherwise,
That is for you to disclose,
yes,
sir.
yes.
They are supposed to disclose the reason to you, otherwise,
Yes.
how will you argue in the
But
court?
they say, my lord, that the file was put up before the highest authority, my lord. The highest authority has, my lord, for a, my lord, of review, my lord, on the matter. That is how, my lord, the matter. They are, my lord, processing the file, my lord. It is not that, my lord, that the file is not processed. They're processing the file, my lord. Hopefully, my lord, things will be sorted out, my lord. Hopefully, things will be sorted out soon, my lord. In fact, I have also persuaded the department, my lord.
Okay. This court by order dated 21st of November 2022. In the presence of the additional Secretary Department of Mines and Minerals Government of Assam has issued a direction to the authorities to consider the case of the appellant in accordance with law and pass an appropriate order.
Vacancies are available. Vacancies are available.
Pass in accordance with, pass an appropriate order, looking to the fact that vacancies are available in the department in the grade 4 category to accommodate the appellant. Full
Yeah.
stop.
SLC is also recommended.
Pursuant to the said direction, the state level committee in its meeting held on 2nd of March 2023 has granted approval has principally has decided that the appellant is to be appointed on the grade 4 category, on the grade 4 post against the grade 4 post. And for that purpose, approval of the finance department is sought. It appears that while letter dated 16th of November 2023, the government of Assam Mines and Mineral Department has sought approval of the finance department, but the same has not been granted till date. On 4/3/2024, Standing Council for Finance Department is directed to complete his instructions as to why the matter regarding compensate appointment to the appellant, referred by the state level committee, has not been approved by the finance department. Mr. Argun Pujari, the Standing Council of the Finance Department, has failed to furnish any reason for non-compliance, for not granting approval by the finance department to the appointment of the appellant. Stop. This should be noticed that the state level committee is headed by the chief secretary of the state, in which the finance secretary is also a member. There is no reason to, in such circumstances, apparently there is no reason for the finance department not to grant approval to the proposal of appointment of the appellant on the grade 4 post in the Mines and Minerals Department. Stop. Taking into consideration overall facts and circumstances of the case. Paragraph. we deem it appropriate to grant 4 weeks time to the finance department to do the needful in the matter, failing which the secretary to the finance department may file his affidavit,
Personal
a personal affidavit
stating the reason.
indicating the reasons for not compliance of, for not granting the said approval. Based on 4 weeks के बाद की date. 22nd April, 22nd of April.
Can it be secretary, in case of secretary, can it be commissioner and secretary because he is the authority.
Commissioner and secretary,
Commissioner and
finance
secretary.
department. Commissioner and secretary है ना? Commissioner and secretary finance department. Yes,
Copy of this order will be furnished to Mr. R.
copy of this order be furnished to Mr. R. Gaur Pujari.
Item 3 and 4.
That's so obliged.
May please your lordship.
Who is counsel appearing for the aims?
May please your lordship. As
Who
per
is counsel appearing for the aims?
lordship, I am.
You are appearing. Why you have not get the notices, sir?
Lordship, we have received the notice from the registry on 11 lordship, and accordingly we have served on 12 lordship. And what is affidavit is yesterday evening I have got the affidavit within a 1 hour affidavit will file. Otherwise, lordship, notice was duly received, lordship. Duly received and endorsement is also there, seal is also there, lordship.
So nobody is appearing
Yes, on 12th we have served him.
on 12th
12 lordship.
and today is
Today's lordship 14 lordship. On 11 lordship, I have received the dusty notice from the registry lordship. And this is the lordship.
Verifying whether any comes.
Look, my humble prayer is that Lordship may be pleased to fix the matter for admission hearing. In the meantime, if the party,
okay, learned counsel, Mr. K. Gogoi, appearing for the aims, has submitted that the notices upon the respondent number 3 and 6 in writ appeal number 467 oblique 2023 and writ appeal number 458 oblique 2023 has been duly served on 12/3/2024. Full stop. A affidavit of this effect. He is going to file an affidavit of this effect during the course of the day. Full stop. List these matter. In such circumstances, service of notice upon the respondent number 3 and 6 in writ appeal number 467 oblique 2023 and 458 oblique 2023 are deemed to be complete. Let this matter be listed on
Third April.
3rd of April for admission.
Oblige, lordship.
DPO.
But there is
Item-
a-
sorry.
there is an interim in item number 4, it may continue. Madam.
Yeah,
There is an interim stay in item number 4.
interim order passed in writ appeal number 458 oblique 2000, 458 oblique 2023 shall remain in currency till next date.
Oblige.
DPO.
Item number 6.
Yes,
Lordship, the basic issue, Lordship, for adjudication before the learner single judge. Lordship, whether the BEd degree obtained by the respondent number 7 was a valid degree. In the writ petition, Lordship, 6 affidavits, total 2 writ petitions were filed. 6 affidavits have been filed by the official respondent. Director of Secondary Education, Commissioner and Secretary of the Government of Assam in the Education Department, and ERC NCT, and also the particular college, that is Bipura PGT College. They filed their affidavits stating also that his BEd degree cannot be considered as a valid degree. And Lordship, the learned single judge did not consider those aspects.
your case is
Lordship,
that this particular respondent
Lordship,
or this particular respondent, respondent number 7, he obtained a degree from an institute, and at the time when he passed the degree or acquired the degree,
Lordship.
that institute was not recognized.
Lordship. In fact, Lordship, the NCT has rejected. their
Rejected, but
application.
later on in the year 2001, the recognition was
The
granted.
recognition was given.
So that would be deemed that all the degrees issued by the institution in the before granting recognition are recognized.
No, in fact, Lordship, the writ petition was decided on relying upon the judgment passed by the Honorable Court in Papanjanath Triparthi's case. That particular paragraph 19, if we read paragraph 19, those colleges who had applied within the period of 6 months, but here in the
Within
instance,
the period of 6 months of which date?
from the date of from the appointed date.
From the appointed date, and what was the appointed date?
Appointed date was, let's say, 1/7/1995.
And 6 months, you
6
mean to
months
say
will
after
come.
1995?
Yes,
You should go through a judgment, we have passed in judgment. In fact, that 6 month, that appointed date was extended up to 1999.
1997. Even that does not cover it.
1999.
99. Even that will also not, because here is a case, let's say, where
We have taken a
NCT has
different-
specifically
go through-
rejected.
Go through that judgment, then argue the matter.
Let's say we'll then admit this case and fix for hearing. Let's say.
Admit, you just go through that judgment,
Okay.
whether your case is there or not.
Okay.
judgment PK Mr. SK Goswami.
You obtain the details,
No.
then argue the matter.
A BEd degree,
That, let's say, I am aware of that, let's say. That judgment.
You are aware of that
Yes,
judgment?
I am aware of the judgment.
Do you have a copy of that judgment?
Lordship, today I don't have, Lordship. Your Lordship has passed the judgment in Musawir Ali's case. Musawir had Lordship, two writ petitions were, Lordship, decided by common order. Lordship has dismissed the writ petition. That is pertaining to, Lordship, the NCT recognition but granted to the particular college. And Lordship, that particular college, Lordship, Association Institute of Education, Hailagande, They had applied prior to the date of the prior to the extended date, 1997. And Lordship, the learned single judge has held that BA degree would be valid. But here, Lordship, the NCT has rejected.
How does it make a difference? You argue it after going through the judgment, you please go through the judgment. After a week,
Lordship, may I kindly fix it in the month of April? I have some medical emergencies, Lordship.
fine, which date?
After this vacation.
On his request.
22nd of April,
Yes, Lord.
and 23rd of April.
Yes, Lord.
And the
Lordship,
request of the land council for the, until unless this matter on 23rd of April.
Lordship, the interim order may kindly be extended. The interim order may kindly be extended.
Interim order is there.
Yes, Lord.
Interim order, if any, shall remain in currency till next day.
Item number 7.
Yeah, please, Your Lordship. Lordship, this application is directed against an order dated 17/11/2017 passed by the learned CAP. Lordship will find that order in page 14. Page 14, Lordship.
Page 14.
And the operative portion, Lordship, will find at page 17. Live issue. 1998 and the this person in service. And he is still working.
Lordship,
He is working.
Lordship, he is going to retire on 30th of April 2025. Next year, 30th of April.
He is working as what? He is
Now,
presently he is executive.
Executive
engineer.
engineer. I'm posted in Delhi.
He?
Delhi, that's.
The last time he was in Delhi.
But your client has already been promoted.
My lord, Lordship, yes, promoted, but because of the, my lord, not granting the promotion, my lord, in time, now he has, my lord, missed the, my lord, now he ought to have been in, my lord, post, my lord, had an executive engineer.
He is already working as an executive engineer.
My lord,
So now if he has been promoted, then what remains?
Lordship, he has grievances, my lord, for last 12 years, my lord, he is, before the, he's in, my lord, this litigation, my lord. Lordship may be pleased to take up my OA if my, after completion of my seniors, my
Last
lord.
12 years he is working as an executive.
No, my lord, not after, because my lord, for not giving the pay scale, he was for 70 years, my lord, 17 years, he was in the same scale, even after granting SCP, even after merger, even after promotion, my lord. So 12 years he was in a same scale, my lord. 6,500 to, my lord, 12,000. So after that, my lord, he has been given promotion, but his juniors were, my lord, well ahead. But because, my lord, after having available vacancies, my lord, since 1999,
Yes.
after, my lord, in spite of having available vacancy, my lord, since 1999, his case was for promotion because he was eligible for promotion after completion of 3 years service, my lord. His case was not considered for promotion, whereas his junior, my lord, though he was ST, but he is ST, my lord.
Mr. Dev Chaudhary,
Lordship.
the operative part is at page 17, para 4.
Yes, Lordship.
You are aggrieved by that.
Yes, Lordship.
Why you are aggrieved? How you are aggrieved?
Lordship, what has happened here was he was promoted on ad hoc basis since there were cases going on in the higher ranks. Therefore, there were no clear vacancies at that point of time. Therefore, in 1998, he allowed others. I take your Lordship to the order. Your Lordship will come to page 82 for a moment.
No, what we are asking you is,
Yes.
at this stage, this order, how does it matter? Because he has already been promoted and he is not aggrieved.
Subsequently, he has been promoted.
He is not aggrieved with the promotion
that-
given to him.
Yes. Subsequently, he has been promoted. Lordship.
But this order is not going to help us. He's asking prospective effect to us. तो फिर तो इनको रिव्यू डिफरेंट भी करना पड़ता है डिफिकल्ट कैसे करेंगे अडॉप्ट करते हैं उसको प्रमोट करते हैं हाँ कैसे कर दिया but he has been promoted without this. Review the petition. He is substantively holding the post of executive engineer.
Yes.
That is a promotional post. Of
Yes,
his.
Lordship.
When was he promoted?
Exact, Lordship.
No, was it it has to be a regular promotion.
It is a regular promotion.
Which is the date of that DPC?
Lordship, I do not have that.
No, Mr. Dev Chaudhary, we are trying to figure out what is the live issue today. If he is holding
No,
a substantive post,
Lordship, at that point of time, this matter was filed. That is okay. But if now, since he has already been promoted, if there is a difference in the seniority,
that
he
is
has to
another
be-
matter.
that has to be challenged. That has not been. challenged.
Junior has already been,
That has not
my
been
lord,
challenged.
gone up above him, my lord. Because of my lord, he has been continuously in this litigation, my lord.
Ms. Das, the difficulty is you
Lordship.
may have a grievance.
Yes,
But
my
your
lord.
case is not commensurate with your grievance.
My lord,
If you have a grievance regarding seniority, ask for it.
my lord may be pleased to take up my OA as well as the judgment passed by the learned tribunal, my lord. Because, my lord, if your lordship take up page 87 of the, my lord, appeal memo, my lord, says writ petition, my lord, 87. Your lordship will find his name at serial number 20 at page 88. At that point of time, he was.
So you are claiming seniority, right? Your grievance is seniority.
Not seniority, my lord.
Then
It's, my lord, pay scale, promotion, my lord, because even merger also, my lord, they have merged. Lordship may be pleased to take up my OA, my lord, because the facts are, my lord, without going through the facts, my lord, it is difficult to, my lord. Lordship, because they have merged two posts, he was initially appointed as design assistant, my lord. Then the fifth pay commission, my lord, it came up, and that scale was, my lord, after, my lord, pre-revised revision was pay was revised, it is 6,500 to, my lord, 12,000. Then, my lord, the post was merged with, my lord, next higher post, that is, my lord, extra assistant director, director, that was merged with effect from 1/1/1996, my lord. Though then he was eligible after, my lord, 3 years of his appointment, my lord, he was eligible to the next higher post. But subsequently, with effect from 1/1/1996, both posts were, my lord, merged. So his scale was, my lord, 6,500 to 12,000. So that was not, my lord, upgraded. Then he.
For a moment, lordship. All the prayers made by the applicant before the tribunal were rejected. And this particular prayer, lordship will see the tribunal has dealt in paragraph 29 of the order.
I would, my lord, correct.
It was
one by
he
one.
who should have come up.
One by.
I would correct, my lord, that was rejected because I prayed before the tribunal with effect from, my lord, in the 1997. But tribunal said no, because there was at that point of time, DPC, during the time of DPC, you did not complete 3 years of service. So that's why you are eligible with effect from the date given by the respondent, the ad hoc promotion, that is 1998. So my prayer for 1990 with effect from 1997 was rejected, because my prayer in the OA was from 1997. So that was rejected. But tribunal said because there was availability of vacancy, because the respondent is, my lord, SC candidate. So there was available vacancy of SC quota. So that's why you would have appointed, because as my the submission has been made that there was dispute regarding seniority. This is not correct, my lord. No cases were pending for in case of seniority, my lord. So at that point of time, 1973 rule was, my lord, prevailing. So as per that rule, he ought to have given the promotion, my lord, after completion of 3 years service, my lord. নাই মোৰ ফোন কৰিছা IAS অফিচাৰে লিখিছে তুমি লিখা নাই IAS অফিচাৰে লিখিছে
Order, what is this order? This order in place of para 33 of the order 417, the para number 4 of the above order be replaced. Which para number?
My lord, because in the earlier occasion, my lord, after earlier order is of 2014, then my lord, the respondents, my lord, herein, my lord, petitioners approached this honorable court, my lord. Honorable court, my lord, without entering into the merit of the case, has observed that since in the year, my lord, in paragraph 33, the date for review DPC was not specifically mentioned. So that's why it was remanded back again to the tribunal. So tribunal just this order passed by person to the order passed by this honorable court, my lord. The main order, your lordship will find at page 157. First order, 4th of July 2014 order, which has been challenged by the present petitioners. So this order is the main order. It is the clarificatory order. The 2017 order is the clarificatory order, as this honorable court has remanded back regarding my lord case paragraph 30.
What the tribunal has clarified.
The date of review DPC, my lord. Date
Review
from which
DPC, your case was that DPC was never held.
never held
Then where is the question of
For-
review DPC?
for giving his promotion with effect from 24th 1998. Because from that date he was given
You were granted promotion
ad hoc promotion.
2004.
1998 ad hoc promotion was
Not
granted.
promotion, but regular promotion from 2004.
2004, that too, my lord, with in the same scale, 6,500 to 10,500. Lordship will takes up the pace, my lord. In the same scale, my lord, up to 2009, he was in the same scale of 6,500 for 17 years, my lord. Even after promotion, his scale has been fixed in that in my lord 6,500 to 10,500. Lordships, for a moment, my lord. Lordships, for a moment, my lord. Lordship will be pleased to take up page 87 for a moment, my lord. 2 pages, my lord. For page 87, your lordship. Relevant portion of page 88. His number is, my lord, 20 serial number. Lordship, Sekhappa Durgappa Harijan. His pay scale is, my lord. It was 88 of 6,500 revised. Again, 2004, again 6,500, 10,500. Lordship, Lordship, 2 pages. Lordship will be pleased to take up 2 pages. Page 88, my lord.
What you are asking for,
My lord.
what you are saying here. In fact, it is for the tribunal to consider all those things after remand.
They
This is,
considered,
they
my lord.
simply said para number 32 is replaced, 33 is
Lordship-
replaced by para number 4.
Lordship
32
is not.
replaced by so and so. How this is very confusing.
This is the order. Main order is, your lordship will find at pace, my lord,
Once the court has remanded the matter, where is the consideration after remand?
I'll take to your lordship to the order passed by this
Where is the
honorable
order of remand?
court, my lord. Yes, my lord.
So order to remand, please.
High Court's order.
High Court order. 19,
Yes.
190.
Yeah, this is the order.
This order very fast.
190. Lordship, 190, my lord.
190.
190, my lord.
I'm sorry, Lordship. No,
This is-
there is a, Lordship, we'll see 183.
My lord,
183, Lordship.
Lordship. This is the order, my lord. Lord, this is the order, my lord. May I read or my lord?
इन्होंने भी गलती किया रिमांड तब तक नहीं हो सकता जब तक ऑर्डर स्टेटस है they have not satisfied the order, only satisfied paragraph. He has only decided paragraph. ऑर्डर को कैसे बनाते हैं whole order has been satisfied. The original application was restored to file.
Earlier order is at page 130.
There must be a proper consideration by the tribunal.
My humble submission is, my lord, properly considered. If your lordship, my lord, may allow me to read the entire judgment passed by the learned tribunal.
Listen, Ms. Das,
Lordship.
please
Lordship.
listen to this.
Lordship.
Whatever happens in this case, it
Lordship.
will help you in future.
Lordship.
There was an order passed by the learned tribunal.
Lordship.
You were aggrieved by that order?
No.
Para 33, who was aggrieved?
We were.
You were aggrieved. You preferred a writ petition.
Lordship.
The division bench has remanded the matter to the tribunal.
Lordship.
Now, it is the established principle of law that a remand cannot take place unless the order is set aside. But in the paragraph 5 of that order, the division benches, for whatever reasons, set aside only the observations in para 33. Be that as it may, if a remand is made, that means the whole order is gone. So a fresh order has to be passed. But probably misunderstanding this order of the division bench, the learned member has only rectified one paragraph.
Lordship.
That is totally wrong. Listen. That is totally wrong. That order will be set aside. And whatever grievance you have, that has to be now comprehensively considered by the CAT and pass a comprehensive judgments. There can't be replacement of one paragraph. This is not permissible under the law. That's the whole thing about it.
Lordship.
Rest you can argue.
Lordship may fix a definite time frame within so and so, Lordship. Let the tribunal take a call on it. I'm
My
not
lord-
agree by anything. Let there be a discussion on.
Justice delayed 12 বছৰ ধৰি পেলাই
But then you have satisfied that.
in the
Saying that the para 32 observations are not. But para 33.
Para-
It's like it's-
was set aside for এইটো ইমান দাম কেনে যাব লাগিছে
It's weird. I don't understand how you can pass the order. All the issues. to be decided. And these directives cannot be implemented. It's not going to help her.
My lord, in the paragraph 32, it is clearly stated that date, my lord. But since in the last paragraph, it was not mentioned, this honorable.
You are agreeing with this order of the tribunal where they have simply, after remand, they have simply said, read para number 32 in place of 33 and read para number
Because
4
my
in
lord,
place of.
because my lord, paragraph 5 of this honorable court's order, in view of the above, this writ petition stands disposed of by interpreting the direction contained in paragraph 33 of the judgment rendered by remanding that matter for fresh consideration on the point indicated above. But points have been indicated that in our effort to understand the direction so made by the tribunal, the learned counsel for either side was asked to throw light on the issue. The explanation rendered by the counsel do not satisfactorily answer the query of this court. A difficulty is created to hear the case on merit unless it is be clearly comprehended as to which DPC has been directed to be reviewed. So which DPC? Only that point was, my lord, the honorable court
But
directed.
your
and-
initial case was that they are granting ad hoc promotions and are not convening DPC.
Lordship.
Which DPC then certainly, no DPC was convened. Where is the question of convening? the
DPC has been convened, but his case was not considered, my lord.
That is
That's
also
why
a
ad hoc
different thing.
promotion was granted, my lord. Ad hoc promotion was continued to be granted. And my lord, for your lordship, my lord, I'm repeatedly, my lord, praying to take up, my lord, 2 pages, my lord.
She's not understanding what we.
I have understood because, my lord, for last 12 years, my lord, I am with this brief, my lord.
You can't help.
Twice, my lord, we have come
You
here.
can't
my lord.
help it. You should have preferred an appeal against this order.
No, my lord, because it is the honorable court has directed to clarify, because in the paragraph 32, my lord. Paragraph 32, my lord, it is
Yes.
clearly stated, my lord. Paragraph 32 has
Yes.
directed from the date of, my lord, the date on which ad hoc promotion was given. So his case, he is to be given regular promotion from 20th of April, my lord, 1998. So it is clearly stated, since in the direction part, 33 paragraph, it was not mentioned. So that was only to clarify, only indicating in paragraph 33 only, my lord, that was directed. So that's why, my lord, there is no point of, my lord, challenging this order, because court was only wanted the date on which the review DPC, his case for promotion is to be considered, my lord. So tribunal has again clarified that point, my lord, by complying with the court's direction, my lord. Because the court's direction is only to the extent of paragraph 33, my lord. If tribunal would have, my lord, passed a fresh order, it would have been, my lord, disobeying of this honorable tribunal's order, my lord. Because honorable court clearly stated paragraph 33.
Because it will be individual.
Lordship, again, my lord, I am repeating to see, my lord, 2 pages. 2 pages, only, my lord, page 88, my lord. Before page 88, lordship. Page 88. Apuni question kiman hobo etu? Page 88 ki aap kiman hobo?
Yes,
Page 87, 88 kiman hobo ya?
yes,
82.
page 88.
Lordship, because my page is not telling with kiman question etu. My lord, 17 October 1997.
Yes,
There, your lordship, page 88, your lordship will find a page, serial number 20. The applicant's name appeared, Sekhappa Durgappa Horizon. Later on, he changed his name, my lord. Your lordship will find the pay scale.
That is a page 80.
Page 80. Page 80.
Find your page 80.
80. My page is not telling. Page 80. Then
yes,
page 81, my lord, next page. This is, my lord, date of 17 October 1997.
yes,
So his revised scale is, my lord, 6,500. Serial number 20, my lord, page 81. Sekhappa Durgappa Horizon. He is, my lord, 6,500 in the 1997. Then your lordship may be pleased to take up page 101.
Page 94.
Page 94, my lord. Page 94. Page 94, my lord, order dated 28 May 2024.
yes,
Here, my lord, your lordship will find, on recommendation of the Departmental Promotion Committee, Group B, the Chairman, Central Water Commission appoint on promotion. The following officers to the Central Water Engineering Group B service the grade of Extra Assistant Director, Assistant Engineer, Mechanical in the scale of 6,500, 10,500. On promotion also, my lord, the same scale in the 2004. From 1994, he has been in the same scale. His name is serial number, my lord, 17. After, even in the year 2009, when he was given promotion, he was in the same scale, that is 6,500 to 10,500. Lordship, the judgment passed by the learned CAT is very clear and elaboration, my lord. Discuss the written statement filed by the, my lord, respondent in the tribunal. It is clear, my lord. Lordship has seen, my lord. On promotion of the same scale, my lord. From the date of joining, he has been in the same scale for 17 years, even after promotion, even after getting SCP.
Lordship, if she has completed, if that was the case, the tribunal has decided that issue in paragraph 29 of the order.
That order is gone. We'll not look into that. That's gone.
Yes.
That's the settled law that no remand can be made without setting aside the order.
Then I leave it to you, Lord.
Nothing can be done about it.
In fact, but it has verified for everybody.
You can maintain the judgment and remand.
Arguments heard at administrative stage finally. Final arguments were heard at administrative stage. Order reserved.
Lord, oblige me.
Supplementary list, item 35.
Maybe the Lordship. My lord, we have challenged the impugned order that Lordship may kindly see page 38. Now, operative portion of the order, Lordship may kindly see page 49, my lord.
Yeah.
Yes,
49. Lordship
Page?
would say, page 49, operative portion of the impugned order, page 49, paras 27, Lordship would say, name of the bidder, Sharat Hazarika, 18,50,562. Gyasuddin, 9,50,650. Abdul Wahab, 6,50,500. But my lord, this Sharat Hazarika was the highest bidder for the remaining period, that is up to 31st March 2024. But settlement of the concerned ferry has been given in the name of Abdul Wahab, who had the bid value of rupees 6,50,500. So this is one aspect of the case, that heavy loss of public exchequer. Now, Lordship, kindly see para 28. No doubt the petitioner has offered the lowest bid. Petitioner in the writ petition, Abdul Wahab. However, as he is the only valid bidder still in the fray, the state's respondent should have to settle the ferry service with the petitioner in terms of the judgment.
The period is expiring on
31st March 2020.
only up to 31st of March.
Yes. But my lord, thing is this, my lord. In the last 2 years' experience, we have seen then saying that there are tendency of litigations. So they seek extension and they give extensions. So that is one apprehension with us because we have lost because totally being the highest bidder, we have been deprived for non-legal reasons. Because the landed single judge lordship would see one sentence, para 28, the state respondents would have page 49, my lord.
Yeah,
So Mahmood, your client did not appear before the single judge?
No, he did not appear.
Why, despite receipt?
No, actually, my lord, that was his mistake. He did not, he came, but he was said that you are the so many highest bidders. So in that we are common men, my lord, they did not see it. But thing is this, expiry order does not mean that would be in violation of law, my lord. Lord, if I even do not appear, even my case is far, far better. Now, London single judge said that lordship kindly say again, page 49, para 28. One sentence would be sufficient. The state respondents would have to settle the ferry service.
they have handed over the query to her.
My lord,
They have handed over the query to him. This,
and that information I do not
Well, I
have.
will take instructions on that, my lord, whether after the single bench's judgment, whether the ferry has been handed over to the private response.
you are for?
My lord, I'm appearing for the standing of IWT, my lord, 1 to 5. Transport Department IWT. We have
But that is not the way. Lordship may also commit order to pass an order that it should be returned to me because I am the highest bidder.
Why don't you find out?
My lord, it has not been settled, been with the appellant, my lord. It was being run on day-to-day basis. After that, my lord,
By whom?
day-to-day basis by departmentally, my lord.
Department.
Department.
Departmentally. After the single bench's judgment, I have to take instructions on whether the ferry has been handed over
Complete your instructions by
by 2, my lord. My lord, otherwise the ferry, the settlement of the ferry, the NIT has already been issued, my lord. By
For the next year.
for the 20.
That's right, but you,
24.
inform us within our,
My lord, I'll
take up
take-
the matter at 12:30.
my lord, I'll take instructions.
1:30.
12:30.
My lord, if I may point out one.
And what is the date of the fresh NIT, if you can?
My lord, on 8/2/24, it has been issued, my lord. The NIT has been issued. It will be completed by 31st.
Complete your instructions. Who have participated in this fresh night?
My lord,
How
if
many persons have participated?
if the technical bit has been opened, maybe we'll be able to find out.
That only if
But-
whether this respondent in the petition has applied, petitioner has applied or not.
My lord, I'll take instructions.
Take instructions, complete your instruction by 12:30.
Obliged.
LL is for hearing, item 8.
Please, sir. The judgment and order passed by learned single judge in WPC number 2595/2013 is, starts from page 77, Your Lordship.
Member of Parliament. बात अगर है कांग्रेस बात है तो yes, yes.
Who's bidding for the other side?
I'm paying for a department, my lord.
And who's bidding for the private respondent?
Madam, earlier I was appeared for a private respondent, madam, but now I cannot appear, madam, because I am appointed as standing counsel elementary education.
Who is the private respondent has made any alternate arrangement?
Madam, I have already informed them, madam, but they did not respond, madam.
Shall we proceed without any counsel on the part of the private respondent?
No, madam, may take it up any other date, madam.
So inform him, otherwise if any order is passed against the private respondent that may affect his. When you were appointed as government counsel,
Madam, 6 months back, madam.
you are duly informed him.
Madam,
Have you sent any registered post or what?
no, not yet, madam.
Send the registered post,
Madam,
otherwise how will you? Just after 4 weeks, you.
madam,
In the
madam,
meantime, you ask your client to make alternate arrangement,
Madam.
otherwise we'll go.
You have to send a communication by registered post
Madam,
and give
I
the
will do
proof
it,
to
madam.
the registry.
madam, obliged.
Not so.
Item number 9 to 11.
My lord, we'll argue, madam. Our client says we'll argue. We have communicated to them. They felt that no, we should argue.
Yes, but you argue will look in the matter, but two things we must point out. Your grievance pertains to two documents. One is 18 September.
And 27.
Which precedes the 2710. 18 September is concerned, it is over. 2710, there is no challenge in the pleading. So we are putting you on notice on that. You have not challenged 2710 with any pleadings in the writ petition. That is why the question was made.
No, 2710 we have done.
The challenge,
No,
but
no,
there is
what
pleading.
we have not done is, my lord, regarding the eventual selection to the IAS. Because we came, actually our basic challenge was, my lord, that equivalence. My lord, I have come across
Mr.
Supreme Court
Chaudhary.
judgment. Yes.
Mr. Chaudhary, we are trying to
No,
have
no.
a very balanced
Very
and
well,
fair
very
approach. You see, primarily 18.9 is the document by means of which their names were forwarded.
Yes,
And 2710 was the equivalence document.
yes.
Now, as far as 18.9 is concerned, you have challenged it on 3 grounds, but one of the grounds is that this was issued prior to the equivalence notification,
Yes.
right? Now, out of this 18.9 recommendation, the 2 persons have already been nominated. UPSC has approved it and they have retired from service.
Yes.
So insofar as 18.9 is concerned, for all practical purposes, there is no live issue. However, you may still argue that 2710 is not valid. 2710 equivalence document is not valid. So we are putting you on notice to argue that there is no pleading in the writ petition.
No, kindly come to page 47
Page
of the writ appeal number 165 of 18.
165.
Please come to page 46 first.
Yes.
Prayer number 2. A writ in the nature of certiorari shall not be issued, setting aside and quashing the.
Prayer is there, no pleadings. Ground of challenge is not there. That's what.
No, page 47. A writ in nature cannot be issued, setting aside and quashing the impute notification dated 27/10/2017 issued by respondent number 6.
What we are pointing it out
is, yes,
you have challenged it because this was done after the nomination. But independently, 27/10/2017 is not under challenge on any pleadings. That's what we are saying.
Please come to para 14, my lord. Page 41. That it is specifically stated herein that petitioners are not against the selection of any competent and eligible non-SCS officers to IS, provided such election appointment is made in strict compliance of the statutory requirement of such administrative functioning. But in the instant case, the entire process has been carried out in gross violation of the statutory provisions. It is pertinent to state herein that the posts belonging to the shortlisted non-SCS officers were declared to be equivalent to the rank of deputy collector of the state civil service, while impute notification dated, but in the consolidated statement prepared by respondent number 6, non-SCS officers were shown to be holding the post equivalent to the post of deputy collector in state civil service from the date of the initial joining. Such action of the respondent authorities are expressly illegal and arbitrary. Moreover, it is pertinent to mention herein that respondent number 6 is having no sanction and authority under law to issue the impute notification dated 27/10/17, not to speak of giving retrospective operation of such notification. Such decision of respondent number 6 cannot be said to be a decision of the state of Assam, inasmuch as while issuing such notification, the constitutional mandate had not been followed. The said notification has been issued without any sanction and authority, and as such, the same is non-SCS.
So on these pleadings in para 41, you want to challenge 27?
Yes, yes, madam. Amongst others, madam. My lord will kindly appreciate one thing, but for this stay order, the matter would have gone back to the, my lord, learned single judge. So actus cure nemem in grave with court's order cannot either, no equity also can be pleaded based on court order, no prejudice also can be caused to anybody. So my lord, what I found from the case laws is, my lord, in a given case, if the parent action is not challenged and consequential action is challenged, Supreme Court has said you can't do. But I couldn't find any authority on the reverse. If parent action is challenged and consequential action is not challenged, then it has not been said by the Supreme Court that it will bar any litigant, my lord. That's the position in law. So here in this case, my lord, but for the stay order, everything would have been over. And kindly see the order sheet, my lord, on how many occasions who has taken time. So therefore, my lord, it will be, my lord, if we succeed in establishing, my lord.
So now, my lord, the issue before us is regarding the maintainability.
Yes.
And we are not inclined to press the merits of the case. Since it may prejudice the case of either of the parties before the
Well-
learned single judge.
Hmm.
You address it on the question of maintainability.
Absolutely. From day one, that was my stand, and today also.
Yes.
But still, I am saying this is just an academic exercise we are going to do now. That was my first opening statement, and today also I am repeating. And at the end of my submission also, that will be my opinion from our side, Lordship, from the state side.
Academic,
Because they have no challenge to important documents. The documents, Lordship, at page 113, the minutes of the selection by UPSC, and
that
also
is-
the
that is
appointment.
for the- That is for the learned single judge to
No,
decide.
that they have no challenge before the learned single judge also. And also,
They order which is in fact, having some semblance or having some applicability in the matter that has not been challenged. That is for the learned single judge to decide.
definitely, Lordship, and also the appointment order of 19th of February.
That is for the learned single judge to consider and decide.
Yes,
Here only the question regarding the maintenance.
absolutely. That because otherwise it will have a ramification in other cases. Yes. So if Lordship is pleased to come to page 77, the first order before the learned single judge. There are three orders of the learned single judge, 28.2, 28.3, and the final impugned order.
77.
Page 77 of the appeal 167/2018 by the state.
Yes.
The petitioner, may I read it, Lordship? Very short order. The petitioner is an association of Assam civil service officers, and they are concerned with the proposed upgradation to the IS cadre of respondent number 8 to 17. The upgradation to the IS cadres is governed by the Indian Administrative Service Appointment by Promotion Regulations 1955. And the Learned Council refers to the fact that the private respondents are not holding post of equivalent to the post of deputy collector in the state civil service as required under Rule 4.1 of the Indian Administrative Service Regulation 1997. The Senior Council refers to the DPC proceedings of 18/9/2017, whereby 10 officers were recommended for upgradation to the IS, and the subsequent notification of 27/10/2017, whereby concerned posts were declared to be equivalent to the post of deputy collectors in the state civil service. The petitioner contends that equivalence to the post has to be notified first in accordance with the Assam Civil Service Rule 1998 and the post of superintendent of taxes, etc. in a later notification of 27/10/2017 and are not shown as equivalent in Schedule 1 of the Civil Service Rules. It is further averred in paragraph 21 that in pursuant to the recommendation of the DPC, the UPSC has included Manjula Saikia, respondent number 8 and respondent number 9 in the final select list for upgradation, and the same is now awaiting approval of the central government. Council submits that the concerned two incumbents are not served for 8 years in equivalent posts and therefore they are disentitled to upgradation to the IS cadres. In view of above, the notice issued, the petitioner to ensure services to the UPSC and private in the interim upgradation of the private respondents to IS should not be made if the equivalent of their post declared later under the notification of 27/9/10/2017. This order was passed on 28/2/2018. Prior to that, on 19/2, they were appointed and they have already joined also. much ahead. And in the month of December, Lordship, the minutes of the selection of UPSC had come into place. Then thereafter, the next order, Lordship will find. Next order. Page 158. 158 page number, the second order. The respondent number so and so for recall of the interim order dated, so the High Court under this order state the upgradation of page 158.
158. Yeah.
So first paragraph regarding the upgrade, second paragraph. The appellant's counsel as also is here, the learned so and so projects that the matter pertains to upgradation to the IAS and the appropriate forum is the Central Administrative Tribunal, and accordingly the jurisdiction of the High Court is questioned by the applicant. So the private respondents as well as the state at the very outset said regarding issue, raised the issue of jurisdiction. However, M. Chaudhary Learned Counsel appearing for the repression projects that the court is also competent to deal with the present matter. The Learned Senior Counsel D thus appears for the respondent number 8, and he submits that the concerned promotion order was notified in the website on 19/2/2018, and immediately on 20/2/2018, the respondent 8 had joined in the IS cadre. In view of above and in accommodate and Dr. the Learned Senior Counsel appearing, this case be listed on 6/4/2018. In the meantime, interim order to continue. So at this stage also, our stand was regarding the jurisdictional part, nothing to do on merit. And finally, the impugned order was delivered on 26th April. Lordship will find that in 161. So from paragraph 1 onwards, various factual things were quoted there. Then 7, the petitioner's side submissions were recorded from paragraph 1 to paragraph 6. Paragraph 7 from the opposite side, Lordship, from the respondent side, what was the stand of the respondents, including the state? On the other hand, Mr. N. Dr. the Learned Senior Counsel appearing for the respondent number 9 submits that the jurisdiction of the High Court is excluded in matters relating to recruitment to All India Service, and he refers to section 14 of the Administrative Tribunal Act 1985 to project that the appropriate forum for the aggrieved party is a Central Administrative Tribunal and not the writ court. The Learned Counsel cites L. Chandrakuma, which I will place little later. 8.1, the Learned Counsel D thus representing the respondent number 8 while adopting the arguments advanced by N. Dr. questions the locus of the Association of the Civil Services to file the writ petition against selection from the non-SCS category under Rule 8.2 and contends that the petitioners cannot be aggrieved party in the selection of respondent number 8 and 9 to the IS cadre. Then I am coming to paragraph 9. Representing the state, the learned so-and-so adopts the arguments of senior counsel and doctor who appears for the response. So this is our stand before the learned single judge till that stage. Now, discussion and decisions. From here, Lordship will find from paragraph 10.1 till 13, 14, up to 12, all regarding the opinion of the Honorable Court for stating the facts about on merit. Paragraph 13, where the learned single judge went, in my humble submission from the main consideration, the 15 names shortlisted from a non-SCS category in pursuance of the notice of 28/2/2017 were considered by the selection committee in their meeting dated 18/9/2017. That is the shortlisting of the candidates from various departments, because 18/28/2017, that was a letter circulated by the state of Assam to various departments of the state to send the names who are eligible for consideration for IS nominations from the non-SCS category. That later also, it is a part of the record. I'll place it also. On merit, that comes actually. That's why I'm not too much into that. But my submission is that from 28/2/2017, the selection process for IS nomination had commenced. That is why our whole contention today is that from 28 to 2017, then 18/9/2017, then the October 27th notification, these are all part of the nomination part for IS category from non-SCS cadres. Out of the shortlisted 15 names, 10 officers belong to the non-SCS category were recommended by the selection committee, and the same was then required to be considered by the UPSC. But what is of significance in this recommendation is that neither 1/1/2006, the relevant date, when the 2 vacancies of IS for non-SCS categories were available, or when the proforma was circulated on 28/2/2017, Annexure 5, or on the date when the selection committee made their recommendation on 18/9/2017, Annexure 6, the recommended incumbents were holding any post equivalent to the post of Deputy Collector of State Civil Service. Therefore, it is apparent that the recommended persons were ineligible for consideration for appointment to the IS under the applicable norms. This is the opinion given by the Honorable Court, where there was no submission from our side. To overcome the infirmity in the decision-making process, the concerned post, Lordship,
We have gone through the order and we are aware of the facts.
Lordship.
So please confine your arguments regarding the maintainability.
Regarding the
Every
maintain,
single judge has dealt with that issue.
yes, that issue is also dealt. Because what I am, it is not only the maintainable, Lordship, my submission is that there are 2 parts here.
From para number 18.
I'll come to that, Lordship. But what I am here in the appeal, I have 2 fronts. One front is the opinion given by the learned single judge on the merit. That also have to go in my submission, Lordship. That is also our prayer, not only on the maintainability. Because those opinions given by the learned single judge, if Lordship is not pleased to interfere, that will remain.
For that, suppose we are simply just suppose we held that yes, that petition is maintainable, then we can very well observe that the learned single judge will decide the matter afresh without being influenced without being influenced by the observations made by
Yes,
the
Lordship.
learned single
I
judge.
fully agree, Lordship. But my problem is, Lordship, I am not privy what opinion Lordship will finally give. So I have to argue on all fronts at this stage. Once the judgment comes, then I will know what Lordship will deliver.
But that's why only we suppose. I started my sentence with suppose. Maybe we may agree with you that yes, not maintainable, it is not maintainable. But so far as regarding this merit part is concerned, or the observations made by the learned single judge on the merits is concerned, for that we are only saying. Yes. So para number 18 onwards, the learned single judge has dealt with the question regarding the
Maintainability.
How that is wrong, you please address on that.
I'll agree, but on merit also, Lordship, we are agreed. Because the opinion given, there is aspersion cast on the state government.
That can be taken care of.
Even we agree with the Lordship.
We agree
No,
with the learned single
whether
judge regarding
their
the question
agreement
of
is not helping me or against me, I have to convince this honorable court. So my consideration is on 2 fronts. One is the maintainability part. If Lordship is pleased to hold that it is not maintainable, but those opinions of the learned single judge remains, that will have an adverse effect in my case in the tribunal.
There's a genuine debate.
Lordship. So on merit, all these paragraphs were there. Now let us come to paragraph 18 on the maintainability part. Let us now examine whether the writ court should entertain this case or whether the CAT is the only forum available for the aggrieved party. In Al Chandra Kumar's case, the Supreme Court, even while declaring that the tribunal will act as the court of first instance in respect of areas of law for which they have been constituted, unequivocally declared that the tribunal cannot act as a substitute for the High Court or the Supreme Court. It was also held that the power of judicial review over legislative action is an integral and essential feature of the Constitution. On the issue of appropriate forum, it will bear repetition that the key challenge here is to the equivalence declaration to post held by the private respondents of the impugn notification of 27/10/2017. the post of superintendent of taxes held by the respondent number 9 is governed by the Assam Taxation Service Rules 1995. Similarly, Assam Industrial Service Rules covers the post of Joint Director of Industries and Commerce held by the respondent number 8. As can be seen, the posts which are equivalent to a post in any other cadre are included in Schedule 1 of the Assam Civil Service Rules 1998, and it is apparent that the two posts of a non-SCS category where the respondent 8 and 9 have served are not declared to be equivalent to the post of deputy collectors in exercise of power under 3.3 of the Assam Civil Service Rules 1998. The concerned service rule covering those posts held by the respondents were made in exercise of power conferred by the proviso to Article 309 of the Constitution of India, and undoubtedly they are in the domain of legislative function of the state. Therefore, if any change is to be made to the concerned service rule, the state will surely be legislative in character. Logically, therefore, even under the ratio of L. Chandra Kumar, the power of judicial review vests in the High Court under Article 226 of the Constitution over legislative action of the state cannot, in my considered assessment, be outstayed in this matter. Sticking on the issue of jurisdiction, it is also necessary to point out that a jurisdictional fact must exist before a tribunal or an authority assumes jurisdiction over a particular matter. When we examine the state action from this perspective, the jurisdiction of the writ court is not outstayed, and such conclusion, this court can draw support in the ratio of Arun Kumar versus Union of India reported in so and so. So this is regarding the jurisdictional fact and etc. I am not reading that. Paragraph 21. The adjudication on disputes which arise of exercise of power by the state in the legislative domain relating to changes in service rule framed under the proviso to Article 309 should best be decided by the High Court. Even in matters pertaining to recruitment to All India Service, where the Central Administrative Tribunal is otherwise competent to exercise jurisdiction under Section 14 of the Tribunal Act 1985, the assumption of jurisdiction by the tribunal will have to be preceded by certain acts to be done by the state government. If those acts of the state government in the domain of legislative function bring under undeserving non-SCS incumbent to the arena of recruitment to the All India Service, and the aggrieved party challenges the state's action, the writ court, in my considered opinion, would surely be better forum to adjudicate on this issue. Pausing here for a moment. Had the challenge being only regarding the equivalence notification of 27th October 2017, my case, I would not have argued anything on maintainability. There is no doubt it is maintainable. Here, the Honorable Court says 2 points in this paragraph. That if it is a part of legislative action, if there is a change of the existing service rules by that notification, if it has a legislative ingredient, then Lordship, it can be considered in a court of under 226. But my submission is, if that be the consider, if that notification is of 27th October is a legislative action, then the appropriate forum would have been a division bench, not by the learned single judge. If it is considered, because the learned single judge has given that the state in the domain of legislative function, it is not legislative function. At that point of time, it was an administrative decision. It was not under 309 of the Constitution of India. It was under Article 162 of the Constitution of India. So that way also it is not maintainable if it is considered to be a legislative action. So all those we are not argued because that was not the stage. Now paragraph 23. The rule of exclusion of writ petition due to availability of alternative remedy is a rule of discretion and is not one of compulsion. In an appropriate case, even when an alternative remedy or forum is available, a writ court may exercise its discretionary jurisdiction or of judicial review, and 3 contingencies of such nature are highlighted in the case of MP, and this was followed in various cases, Whirlpool, etc. All cases, the 3 conditions. Those conditions are not available here. Taking a cue from this, in cases where the orders or proceedings are wholly without jurisdiction, the writ court intervention, even in matters pertaining to recruitment to All India Civil Service, cannot automatically be outstayed. Here, the state government has decided to confer undue benefit to the non-SCS category incumbent, and the consequential process of recruitment to the IS proceeds only on the basis of state government's decision in the realm of state's legislative domain. In matters like this, the more appropriate forum in my considered understanding is not the tribunal, but the writ court. I fully agree if it is that way, then it is by the division bench, not by the learned single judge, according to our high court rules. The number of persons to be appointed to IS from the category of non-SCS at any time must not exceed 15% to be appointed under Rule 8 with the provision of Rule 9(1) of the recruitment rules. In present case, the total vacancy of Rule 8,
That is now.
that is again on merit. So my submission is, Lordship, that the learned single judge thought or considered it to be a act. An extra fiber repetition. Page number. Page 68. Page 68. So the process started from 28th February 2017, page 68. The notification was of 27th October. And prior to that, in September, Lordship, the first screening was done. So 28th February 2017. So the process of appointment of non-SCS officers to IS by selection during the select year 2016 had commenced. Lordship will kindly see, this was issued by the Secretary to Government of Assam Personnel A Department. May I read it, Lordship? Because this is the starting point when the ball was set to motion. To all additional chief secretaries, principal secretaries, commissioner and secretaries of Government of Assam, subject appointment of non-SCS officers to IS by selection during the select year 2016. With reference to above, I am directed to state that in accordance with the Regulation 4 of the IS Appointment by Selection Regulation 1997, the state government proposes to consider cases of non-SCS officers of the state government for appointment to the IS by selection. The officers to be considered should satisfy the following conditions. These are the conditions. The officers should be outstanding merit. The officers should hold a gazetted post in a substantive capacity. The officer should have completed not less than 8 years of continuous service in the post of the state government on 1/1/2016, equivalent to the post of Deputy Collector of Civil Services. The officers should be below 56 years. Again, pausing here, all these officers who were recommended, they were far ahead than these basic qualifications. It is not that government has done something wrong or favored some blue-eyed person. It is not a case of that. In our affidavit, we'll come with clear position. But all these officers whose name were there in the first initial 15, the criteria, what was said, all the persons 15, they were far above the criteria. Overqualified.
Just a minute.
1 minute.
Filter also. ये तो सारा शेड्यूल अमेंड करके करना ये नोटिफिकेशन ये मैं किस तरह करते
Yes.
Lordship. So I therefore request the names of not more than 2 officers as per pro forma below under your administrative control, whom you consider to be eligible and who satisfies the conditions mentioned above may be recommended to this department latest by 31/3/2017.
Mr. Sekhya, just to interrupt you for a second. This equivalence notification.
Yes.
27, we are just asking questions to clarify.
Yes,
our
Lordship.
doubts. This is going to be used even for future purposes.
Yes, Lordship.
So is it not necessary that this should be incorporated by amending the schedule of the relevant rules?
Absolutely no. The learned signature, where there is a commitment of mistake in my humble submission, again, I am submitting with all humility. According to learned signature, there should be amendment of the civil services rules. And
Schedule
these
one. Schedule 1.
civil services rules 1, their names will never come here. They have their parallel different rules. One is covered by the industrial service rules. The other one is covered by the taxation rules. That is why these things were, we did not get the
That's
opportunity to
correct.
clarify.
That's correct. You may be correct, but is
For
it
that,
not
the civil
necessary
service rules is not required to be touched. That's all.
right. But some rule will have to be amended somewhere to make it.
Absolutely no. Absolutely no. Because why I'm saying, what is the requirement? That they should be in 8 years. There is an administrative requirement only to give the balance. They have to be as superintendent of taxes. Suppose let us take the example of Rakesh Agarwal. He was superintendent of taxes way back in 2006. He has completed 8 years. When he was considered, he was commissioner of taxes.
No, Mr. Sekhya, we have understood your argument on that count. These
Joint
are all
Commissioner of
eligibility issues. We are not on the eligibility issue.
Lordship.
We are saying that whoever is eligible, that will be determined by the rules.
Yes.
But which posts are equivalent to
Yes.
which post?
There are various parameters, responsibility and duties, pay scale, pay band, all these things have to be considered.
Are these things not required to be incorporated in the relevant rules? That's what we are saying.
Sometimes it is not required, Lordship.
Sometimes, but here.
Here, just to, because this is the first time, for the first time, non-SCS persons were recommended for this IR. Till this time, Lordship, although that their scope was there, never there was not a single person from non-state civil services cadre was nominated for IS.
We followed, but you said that there is no requirement. to
Absolutely no,
incorporate the rules.
Because what are the parameters we see when we give the equivalence? Suppose let us example for education purpose, a degree from a particular university of Agra for Hindi qualification. It is considered to be equivalent to the Guwahati University's master postgraduate degree. Then a notification is required to be issued by for that we don't have to amend the Guwahati University Act. When equivalence is given from 2 different areas.
This notification.
How can we merge the 2 acts together?
Notification dated 27th of this October 2017.
Lordship.
Is issued by the state government by exercising powers under which rules or which act?
If page 70, let me see. For the purpose of appointment of non-SCS, the following post, if there is no other purpose, the residuary power is always there under Article 162 of the Constitution to the state government. Article 162.
There must be some power with the state government to declare equivalence of non-SCS post to the rank of the equivalent to the rank of deputy directors of the state civil services. There must be some power. Otherwise, how the government can pass such issues as notification without having any power.
Prima facie, my submission is 162, but if Lordship wants further answer from me, then I have to examine Lordship.
Yes. Under what power the state government has issued this notification?
Appointment or selection regulation.
Says what?
State government to send proposal for consideration.
Yes, that declaration has to be given.
Send proposal?
They have
comes to the, then four sub three, Roman 3.
Page 64.
Not less than 8 years of continuous service under the state government the first day of January in the year, in which case is being considered in any of the posts which has been declared equivalent to the post
That which is there.
of the deputy collector in the state civil service proposed. So it is later on the regulation.
Mr. Das, uh, you are very close, but not quite there. My lord's query is slightly different. These are all criterias. This rule says the state government may send rules for the equivalent post. But the state government declaring the post to be equivalent, is this a legislative or is it an administrative function? Number one, just a minute. If it is an administrative function, there must be a source of power for that. Some statutory provisions, some rules has to be there. Or is it that there is no rules here? It is just
Yes.
issued under
Article 160, may I read it, Lordship, of the Constitution?
160.
Extent of executive power of state. Subject to the provisions of this Constitution, the executive power of a state shall extend to the matters with respect to which the legislature of the state has power to make laws. Provided that in any matter with respect to which the legislature of the state and the parliament have power to make laws, the executive power of the state shall be subject to and limited by the executive power expressly conferred by this Constitution or any law made by parliament upon the union or authorities thereof. So my submission is.
That's correct. But the question again is slightly different. Is there a statute which provides for the equivalence mechanism? Or
That
is
is,
it that there
I
is
have
no
to
statute?
examine that part. I have to examine.
What powers the state government has issued this notification?
Yes, that
Where
power.
the government has derived that power. Under which
The
law?
Constitution is the
You
source of
can't-
power here.
Yeah,
We can
just-
make laws. We have
Just
two
a
options.
Just a minute, you can't, tomorrow, if you issue a notification that a low divisional clerk is equivalent.
Absolutely no.
Is equivalent to
No,
the
no, no,
deputy
no.
collector. How
That
can you
is
say,
where
sir?
my learned friend has rightly pointed out, Lordship. That point is that he should be at the equivalence of deputy commissioner.
Deputy collector.
Deputy collector, deputy commissioner, same level.
That is,
Deputy collector.
you plus satisfied
So-
that under, the state government has derived that power to issue this notification under which law?
I am showing, but let me examine them. I'll examine them. Let me give me.
Your stand is 162. That may be correct. If there is no rules, no.
Absolutely. We have two options.
But is it that there is no rule, no?
That I have to
statute?
examine, Lordship, because we are not on merit till now.
Correct, correct.
There, we have two options. Either
that-
we can invoke Article
It's
309.
It's a question of importance. Since you are arguing that this declaration of equivalence is not a legislative function. That for that reason and therefore the writ petition is not maintainable.
That is my second line, which I developed during my reading, Lordship. My original reading is L. Chandra Kumar. L. Chandra Kumar is the main case, followed by the Arunachal Division Bench of our High Court.
You have to
On a
meet-
single bench.
You have to meet the.
I'll meet Lordship. I'll
you have
satisfy
to
this
meet
honorable.
the finding of the learned single judge that it's not what the learned single judge we gathered from the order, that it's a legislative function.
Yes.
And therefore, this the business of declaring equivalence is a legislative function and therefore it is maintainable. On the other hand, you are saying that no, it's not a legislative function. And it's a administrative function, and for that reason,
Yes.
he has to go, the persons aggrieved have to go
Yes.
to the approach to the tribunal.
Yes.
This is what your stand is. So first of all, what that, to satisfy us, please show us that the state government derived this power of declaring a post equivalent to deputy collector post under which provision of law?
That, yes, Lordship. For that, I have to examine number one. And straightway, if Lordship wants the answer from me, then Article 162 is always there. That is the source. That is the
That's another.
fountain.
No.
That is the source of power. Article 162.
Mr. Saikya,
Lordship.
this is just a corollary to the query
Lordship.
made by my lord. You see, we appreciate what you are saying. 162 is the residuary power of the state to take decisions in matters where the legislative function extends. Correct? But you will probably agree that if there is a statute already in existence or a provision of the rule which operates in the field, then you cannot substitute or resort to 162.
I agree, Lordship.
Now, what we are asking is, since there are rules and schedules which deals with the category of posts which come within the zone, is it a case that the equivalence of posts will also have to be notified in deference to power conferred under some statute or rule? Or is it that there is no such statute or rule, but under 162?
Lordship.
Kindly bear with me.
Yes, Lordship.
Bear with us for a minute. This question is very, very relevant because if there is a power in the statute or the rules and that has not been followed, then there will be consequences.
I agree.
If there is no such mandate of any rule or any statutory rule, or we are referring to 309 proviso, etc., rules framed under, then obviously the question would be that it is an action under 162 Article 1, and therefore it has to be examined. The findings of the learned single judge has to be examined from that perspective.
I fully agree.
So this answer to this question will, in a way, be the fountainhead of the arguments flowing from different streams because of the findings recorded by the learned single judge. Without a clarity on that, it will be very difficult to take a decision.
Lordship. So
You followed the question.
yes, I follow the Lordship. For that, I have to look into the files. What was the exercise they have done? They have done it very casually, mechanically, or they have really looked into some rules and doing it. But for otherwise, it is always that pay commission. There are various factors, various parameters to give equivalence. One is the pay structure, Lordship.
We're not on the merit of equivalence.
Yes.
We're on the procedure.
So I'll examine and I'll come back to this honorable court because we have not taken any instruction on those.
Because you will appreciate that this will have a bearing in the future course also. Without having clarity on that, it will not be proper to.
Because the learned single judge brought the angle of legislative exercise of power by the state.
Yes,
so that angle, Lordship, will definitely
yes, but there is no, perhaps that finding is not there, that this is a legislative exercise relatable to or traceable to which source of.
Yes, because learned single judge found one thing, that there has to be an amendment of the civil service rules.
Correct. That's why it is.
But that is not required in my humble submission. Because how can a person not belonging to, because there are two streams. One is the civil service cadre, one is the non-SCS cadre. So why SCS cadre, the civil service cadre's rule will govern the service or the status of the employees there in their rule.
No, correct. And then there is a second limb of it.
Lord.
Supposing it transpires that this is a legislative action and was required to be carried out in a particular manner, then perhaps the state will have no difficulty in agreeing.
Yes.
That unless the rules are amended,
yes,
this notification would lose its force, 2710.
Definitely.
In that case, the outcome of these proceedings will be different.
Yes, we have two options, either 162 or 309. 309. We have not done it in 309. That is why the other option is 162. What 362 says, recruitment and conditions of service serving in the union or the state.
No,
we are not bringing.
That's about framing rules afresh. We are saying
the learned secretary said that there should be amendment in the rules.
Correct. Is there an existing rule which
I'll
requires?
examine, Lordship.
That's
I'll
the point.
Lordship. Definitely.
That is why the question of amendment.
Yes, Lordship. So,
amendment can happen only to an existing rule.
Definitely, I will examine that part, how that notification was issued, because we have not responded to the notification till now.
And you should examine this aspect because you are going to use these equivalents, let's presume, for a long time to come, for future purposes. So this question has to be resolved.
I fully agree.
And if it is actually a legislative function which draws its source.
If they give up the other prayers and only keep this prayer, then I will immediately accede that this is a maintainable case. if they have to give up the other prayers.
Other prayer means?
The prayers regarding the selection already done. If they give up that, only the issue of equivalent, that notification is a subject matter.
Selection already done with prayer.
Now, in fact, the question of equivalence is only the matter.
If
And nothing else in this
If-
matter. So
yes,
far as
if that
regarding
is even
their
done, the learned single judge will be
selection
the
or
right.
their appointment or whatever it may, that part is over.
No, this is.
Other prayer.
They are telling to the earlier bank. So, Mr. Chaudhary, what do you respond to that? We are not asking, probably you are not asking for setting aside the appointment of those candidates who have already been appointed and
No,
retired.
my lord will, while remanding the matter to the learned single judge, lordship will keep everything open. No.
Just a minute. What
Sir,
Mr.
just
Saikia has
what has
suggested,
fallen,
what
that
Mr.
to-
Saikia has suggested, that
Yes.
if you are challenging only this validity of this
Yes.
notification, certainly that is maintainable. Writ petition is maintainable. Simultaneously, you have to give up the other challenges.
No, why should I take dictation from state, my lord?
Just there is no question of declaration. It is a suggestion.
No, it can't be, he need not suggest, my lord. His duty
I'm
is to
suggesting
state,
the court.
defend the interest
I am
of
not
the state.
suggesting you.
I think let him defend the interest of the state. We'll take care of our client's interest, my lord. No, my lord, matter is very simple. In fact, learned single judge only dealt with that. Learned single judge only dealt with the legality and validity of 27-10-17 exercise. Learned single judge is not, even when we have not posed a challenge, where was the scope for the?
Chaudhary, learned single judge has dealt with each and every aspect. And in fact,
There I agree,
he
my
has-
lord.
He has almost
Decided the case.
decided the
Yes,
case.
there I agree, my lord. That's why when it has fallen for your lordships, that in the event we remand the matter, there I immediately agreed, my lord. If the learned single judge is to now decide the matter, they will start from afresh. That there we are agreeing, my lord. In fact, when suggestion fell from your lordships, we'll keep everything open. We'll take a call, my lord.
Other
Whatever
prayers, if-
plea is available to us in law, we'll take before the learned single judge.
No, Lord, my submission is very clear.
No, all right.
Let me bring the instructions on the.
One second, if your lordship permits. After L. Chandra, there is another judgment of the Supreme Court. A judgment of the Supreme Court. How it was dealt by Supreme Court 2010 and later by the Bombay High Court in 2022 by division bench. It is not the area, only the virus of legislation, then is on the High Court. But excepting legislation, it is the tribunal where the Supreme Court said that will be dealt by the tribunal itself. I am satisfied, your lordship, how the effects of death after El Chandra judgment. I will show that.
My lord, if I go to the Central Administrative Tribunal only with this, my lord, the grievance of equivalence, my petition will be dismissed on the ground that we have no jurisdiction.
Correct. Mr. Das, the other day, one more question was put, leaving aside the legislative issue. L. Chandrakumar does not oust the jurisdiction of the High Court, but says it's more on a propriety count that a litigant must first approach the tribunal in these matters where there is a violation of conditions of service. Now, this is a case where after hearing both sides, the learned single judges, for whatever reason, held that this is a fit case to be decided by the High Court by giving his views that these are the facets of challenges. Now, once the single judge is held for whatever reason by exercising discretionary jurisdiction, the writ appellate court being an appealing principle, why should he reverse that finding? If it was a case when they would have come to the court for the first time, and at the stage of admission, this issue was raked up and the matter was remanded, the matter would have been very different. But now the learned single judge has not only admitted the case, but given reasons as to why this matter has to be heard by the writ court. So unless there is perversity in the finding, why should we substitute our views?
No, what was that case? Our case was regarding maintainability. Our case hold that writ petition is not maintainable. Because
No, that's correct. The query is slightly different. It's not that this view of the learned single judge is perverse. It's one possible view. Please follow. Please try to understand the query. The view of the learned single judge is a possible view. If it is a possible view, when two views are possible, why should the writ appellate could reverse that view? We would request you to kindly address arguments, both of you.
Yes, Lordship. And there is a contra argument of another learned single judge. Identical facts, not maintainable.
There you referred last time.
Contra views.
It was earlier.
And that was earlier.
23rd of April.
Highly
Looking for
obliged,
some
Lordship.
steaming debate on that.
3rd of April.
23rd of April, my lord, post Bihu.
Actually,
In any case, my lord, he has retired, therefore, if we are to succeed, we'll succeed on these facts. I would say all the same. But my lord, I was only thinking one thing, I'm just indicating it, my lord. Sampat Kumar was referred to in L. Chandra Kumar. In Sampat Kumar, my lord, the ouster of jurisdiction was upheld. That is how this matter was referred to Constitution Court. Now the Constitution then says, my lord, apart from anything else, that 226 is the inviolable basic structure of the Constitution. It cannot be taken away by any parliamentary legislation, it being a constituent law. They have coupled with the, my lord, Babu Bhai's case, where ouster of jurisdiction is not to be readily inferred. What has fallen from your Lordship Justice Suman Sham is absolutely correct, my lord.
That's why honorable brother.
Yes.
Suggested.
Precisely, that's the
Even
point.
though if the learned single judge is entered in the
Yes.
petition, why should we,
Merely because another view is possible.
another view is possible? One should- Yes,
That's the absolutely correct, madam.
23rd.
Deeply.
Highly obliged.
Last over matter 35.
Yes, Ms. Bora, what is your
Yes, Lordship, I have received instruction, my lord. The 7 bidders has participated in the technical bid process along with the writ appellant and the private respondent. They have participated. Technical bid was open on 29th of February,
And who is running the ferry now?
departmentally.
Simply observe that after 31st of March 2024, no extension would be granted, will be granted to the this responded
Ferry is being
writ
Seven.
petitioner.
My lord, ferry is running
Then-
departmentally.
As of till today, no ending over.
No handing over.
No handing over. I have also received instruction. No handing over is there. Here in writ appeal,
They may process. Try to finalize it.
Issue notice. Issue notice of stay application also. In the meantime, the direction of the direction given by the learned single judge of handing over the query services to the writ petitioner. Respondent number
7 in this writ
7
appeal.
is appellant.
7 in this appeal
Yeah.
shall remain stayed. Full stop. It is informed that the department has already issued a fresh NIT.
Yeah.
And pursuant to that, the appellant as well as the respondent number 7 herein has also applied along with several other bidders. And therefore, for settlement of the fishery in question,
Ferry
fishery
service.
fishery services,
Ferry, sir.
ferry services. we deem it appropriate to grant liberty to the respondent, Fishery Department,
IWT, my lord.
IW, IWD Department to continue with the process of tender and conclude the same before 31st of March 2024.
Lordship.
Notices are made returnable. So and so is appearing on behalf of so and so. Let notices be issued to other respondents जो नहीं appear हो रहा.
You have for 1 to 6.
My lord, 1 to 5, my lord.
1 to 5. Who is for 6?
Yeah, private respondents.
6 and 7.
6 and 7 are private respondents.
Let notices be issued to the respondent number 6.
I am deeply obliged, my lord.
For hearing, item 12.
Ready? This matter relates to state of Mizoram lordship, and the issue is relating to absorption. When there is no provision of absorption in the service rules, whether by invoking the power of relaxation, the state can do it or not. That is the question involved here. The basic facts of the case is that lordship in 2011, the incumbent, he is a grade 1 medical health officer of Mizoram. His parent department is ESIC, that is Employees State Insurance Corporation. And he was in Delhi, under central government. He came to Mizoram Health Services in 2011.
12, 13, sub Papa guy. It's gonna now ruin my whole day effectively.
May I continue? So initially he was for 3 years, then it was extended by another 2 years. And under the regulations also, rules also, maximum 5 years deputation is permissible. So in 2013, he completed the first 3 years. Then at 14, he was extended. And during that time, lordship, there are 2 grounds on which the government has invoked the power of section 30. I'll place that also, lordship, the power of relaxation. That he came from the insurance background, and he was the pioneer in implementing the there's a scheme of the insurance for the state health department, that Rashtriya Swasthya Bima Yojana. So he was the pioneer in and successfully implemented the scheme in Mizoram, and also the Mizoram State Healthcare Scheme. So that is one reason why the government gave importance for his continuation. And also at the time, in the month of February 2014, when he was preparing to go back to his parent department, his wife died in a accident, lordship, and he has 2 minor children. And therefore, he also gave a representation for giving him absorption in the Mizoram Health Service. All the formalities which are required, that there are certain requirements when a relaxation is to be given, that the State Service Commission has to be consulted, and other requirements from the various departments and other entities, all these requirements were fulfilled while giving him the absorption in the state health services. He belongs to grade 1 service. And the writ petitioners, when they file the writ petition, they belong to the category of grade 3. And when he was given the absorption, he was placed at the lowest position in grade 1 inter-se seniority list. No way the grade 3 employees at that point of time, grade 3 state health officers, state health medical officers, were prejudiced. So if we look at the impugned order, lordship will find at page 76. August 2015, and we are in 2024 now. About 9 years have gone. In exercise of the power conferred by Rule 30 of the Mizoram Health Service Rules 2009, notified dated so and published in the Mizoram Gazette on 17/2/2010, and in interest of public service, the Governor of Mizoram is pleased to relax Rule 10(1) and 10(3) of the Mizoram Health Service Rules 2009 as amended for absorption of Dr. C. Lalthanpara, Chief Medical Officer of the Employees State Insurance Corporation, Government of India, to Grade 1 under GDMO sub-cadre of Mizoram Health Services, Health and Family Welfare Department. This notification is issued in consultation with Mizoram Public Service Commission by dated 12/8/2015. And next page, Lordship, there is the posting order of 1st September 2015 at page 77. In relaxation of Rule 10(1) and 10(3) of the Mizoram Health Services Rules 2009, by notification dated 28 August 2015, and in the interest of public service, the Governor of Mizoram is pleased to absorb Sri L. Lalthanpara, Chief Medical Officer, Employees State Insurance Corporation, Government of India, to Grade 1 of Mizoram Health Services under GDMO subdivision, subcadre Health and Family Welfare Department, Government of Mizoram, on permanent basis with effect from 11/5/2015 in the scale of so-and-so pay band 3. Dr. Sri Lalthanpara will be posted in the Director of Health Services attached to Mizoram State Health Service Society until further orders. He may draw his pay allowances, etc. from the specified. So he was posted thereby. After this, Lordship, the representation from the petitioner's side, it came on 8 October 2015, 9th October. At page 80 is the English translation. Their basic grievance is reflected in the penultimate paragraph of page 80. The Mizoram Government Doctors Association have been consulted regarding his absorption. However, my disappointment absorption of Dr. C. Lalthanpara to Grade 1 was done when steps were being taken as desired by the MGDA for appointment of new entries. Grade 3.
Just a minute. Finding here. There is no provision in the Mizoram Health Service related for absorption. Absorption का provision rules में नहीं होता. Because हमारे मतलब no service rule provides for power of absorption. There is deputation absorption. These are governed by the. They follow it's a fundamental rule. They don't.
Yeah,
deputation. Relaxation is good. Mr. Saika, we have read the judgment. Just two queries. what is the relaxation given to the appellant here? If the relaxation is to waive the requirement of rule, that's not relaxation. That will be violative of conditions of absorption. But you may also indicate the power of deputation, etc., absorption. These may or may not be strictly required to be there in the rules, because maybe the FRSR and all these things will come into play. So to that extent, the matter, the findings of the learned single judge can be examined. But even if you bring someone on deputation and thereafter absolve him, if the rules do not permit that person to hold a post, that can it be that can it be diluted? That's not relaxation.
There is no such dilution.
Just absorption के बारे में rules नहीं है। वो जरूरी नहीं। Deputation is for that is I understand that the government he has to meet the requirement of this. नहीं तो absorb करने के बाद जो पोस्ट में उसको लाया जाए वो पोस्ट होल्ड करने के लिए उसको क्वेश्चन बताना कोई ये वो लाया हेल्थ में आया है हेल्थ में डेपुटेशन ही वाज अर्लियर इन इंश्योरेंस उसका चाहते ये ग्रेड 1 में पोस्ट होल्ड करने के लिए अगर रूल्स के अंदर क्वालिफिकेशन I think I want to relaxing of one condition of service, which is some of the state employees, employees पहले तो उसका डेपुटेशन है परमिशन डेपुटेशन में लाने के लिए he has to be so Mr. Sekya, to bring him on deputation, he was an employee of the insurance
of the central government.
To bring him on deputation in that post, he has to meet the requirement of the
There is no dispute on that regarding his qualification.
No, not the qualification. The post he was holding on deputation.
He is qualified. There is no dispute on that. There is no. He was grade 1. He has all the qualifications.
Then why was the need to relax?
Relax because he has to go back to his parent department. They want to permanently retain him.
That is absorption.
Absorption.
Why did you have to relax the provisions of the rules?
Because there is no provision of absorption in the rules. That is the case. There is no provision of absorption. In special cases, government can relax the rules to absorb. That is my case. And whether those conditions were fulfilled or not, whether that situation has arisen or not, whether there is exigency of service or not, this is the area to be seen. And the learned single judge said that no such materials were placed before the learned single judge in the writ process, which are in fact part of the records, which a part I'm going to show. So basically, it is a case of conditions of service and not conditions of recruitment.
And he is still continuing in
Still
the.
continuing, Lord.
Because he is
He has been released, given NOC by the parent department in 2014 itself.
Social powers to E 30. 30.
By exercising. Suspend. Repeat.
Yes, please.
So the power of relaxation, page 49.
Rule 30.
Rule 30. Power of the governor to dispense with, amend, repeal, or relax any rule where the governor is satisfied that the operation of any of these rules caused undue hardship in any particular case, or that in the exigency of public service, where I'm harping on this, as well as for effective implementation of this rule, it is necessary he may dispense with or relax or amend and repeal such particular rule or rules or any of the schedules of these rules to such extent or subject to such condition as he may consider necessary in consultation with the Commission through the Department of Personnel and Administrative Reform from time to time, provided that the case of any person shall not be dealt with in any manner except under this Article 311 of the Constitution, as may be less favorable to him than provided by any of these rules. Provided further that any such dispensation or relaxation in any individual shall not be precedent or a binding policy of the government in any other case. So this is the requirement for relaxation. So what is to be relaxed? Actually, Lordship, that Rule 10, page 45. Appointment to the service. All appointments to the service after commencement of this rule shall be made and notified in the Gazette by the government, and no such appointment shall be made except in the manner specified in Rule 8. 2. All appointments to the service shall be made in the appropriate grades of the service and not against specific posts. All appointments to the service in the higher grade of time scale of pay shall be made only by promotion in accordance with the appropriate provisions under these rules, except those holder of degrees of diplomas or specialties super special in a particular discipline, as specified in Rule 9.6. Other things being equal, preference will be given to those persons having rural area experience. So here the relaxation has to be done regarding 10.1 and 10.3. And regarding the direct recruitment at Rule 9 and recruitment to service at Rule 8, all these posts, direct recruitment, 100% of substantive. Rule 8 says recruitment to the service after the commencement of these rules shall be by the following method: 100% of the substantive posts in the grade 3 of GDMO. There are 3 grades, Lordship. That 3 grades, Lordship will find at page 43. Down below, 5 rule, sub-rule 3 says each subgrade shall have the following grades: GDMO, dental surgeon, Ayush doctors, serial number 1 grade, special grade, grade 1, grade 2, grade 3. So only in grade 3 there can be direct recruitments under these rules. And qualifications are there, Lordship. There is no dispute regarding the qualification at any stage. So the writ petitioners who challenge my absorptions, they belong to grade 3 at that point of time. After the judgment in 2016, they became grade 2, and now they are in grade 3. Sorry, grade 1. They are in grade 1. Whereas I joined on deputation as grade 1 in 2011. In 2014-15, I was still in grade 1. And when I was absorbed in 2015, August 24, I was given grade 1, but at the last position of grade 1. So there was no prejudice done to any person. At that point of time, they were in grade 3. So while giving the interstate seniority, I was placed at the bottom of the list in grade 1. So the requirement for relaxing the rule, the governor has to be pleased that there is a requirement of his service on the basis of exigency of public service. And for that, certain criteria has to be fulfilled. Certain consultation has to be done. All these things were done. Even their association, Medical Doctors Association, they also gave no objection certificate. And government has taken a very conscious decision. And if Lordship is pleased to go to the judgment part.
So, Mr. Saike, what is wrong with the learned single judges?
Yes, that is what I'm placing. Paragraph 5, page 136 of the learned single judge. On the basis of submission, paragraph 5, 1-line submission from their side, which is totally incorrect. The petitioner counsel further submits that no reasons have been given by the state respondents for relaxation of the Mizoram Health Service Rules 2009 to arbitrarily absorb the respondent number 6. So no reason was given. That is the submission, and which was accepted by the learned single judge. Now coming to paragraph. Paragraph 11. Paragraph 12. May I read 11 also? A perusal of Rule 30 of the Mizoram Health Service Rules 2009 shows that the governor, if satisfied that the operation of any of the rules causes undue hardship in particular case or exigency of service, as well as for effective implementation of the rules, he may relax any particular rule in consultation with the Commission through the Department of Personnel and Administrative Reforms from time to time. In this particular case, though the affidavit of the government and the Mizoram Public Service Commission states that Mizoram Public Service Commission was consulted with regard to the proposal for absorption of the respondent number 6, nothing has been produced by the state respondents as to why the respondent number 6 has been absorbed into Mizoram Health Service. Lordship may kindly note this, that nothing has been produced. The respondents have also not shown under what statutory rule, regulation, or order having the force of law the respondent number 6, who was on deputation to the government of Mizoram, has been absorbed into the government of Mizoram in the Mizoram Health Service. So the no rule was quoted. That was a second. The 12. The relaxation of rules specifically provides that a rule may be relaxed if it causes undue hardship in a particular case or in exigency of public service, as well as for effective implementation of the rules. Accordingly, the state respondents were duty bound to give proper reason of absorption of respondent number 6. The state respondents have not produced any documents giving the reasons as to why respondent number 6 was absorbed. So this is again repetition, that the state government have not produced any document giving the reasons as to why the respondent number 6 was absorbed into the Mizoram Health Service, except by stating in their affidavit that the rules were relaxed for absorption of respondent number 6 for effective implementation of RSBY and MHHC scheme. Now, paragraph 16. In the present case, there is nothing to show that RSBY and MHHC schemes being implemented by the government will falter or will not be implemented if the respondent 6 is not absorbed into the Mizoram Health Service. The reason of absorption of the respondent number 6 cannot be generalized, and justifiable reasons to have been given for the same. Special reasons have to be given for invoking the relaxation power. So what is our special reason? That Lordship will kindly come to page 70. This is a letter written by the Director, Principal Director, Health and Family Welfare Department, Government of Mizoram, addressed to the Principal Secretary of the Department. Two reasons are cited. Please find here.
Mr. Singh. Prima facie, we are of the view that reasons are there.
Reasons are there.
Para 20 and 21 of the judgment. Impugned judgment.
Yes, absorption for the
20 and 21.
yes.
The impugned.
The state government cannot act in an arbitrary manner in absorbing the respondent number 6 to the Mizoram Health Service by relaxing 10(1)(3) of the Mizoram Health Service rules. No other mode of recruitment or appointment to the Mizoram Health Service remains except by way of promotion. For absorption of the respondent 6, the state governments were duty bound to make some statutory rule, regulation, scheme, or order having the force of law by which the respondent number 6 could have been absorbed into the Mizoram Health Service. Moreover, however, as the same has not been done, the absorption of respondent 6 by notification dated 1/9/2015 is arbitrary and same is accordingly set aside. Any consequential order are set aside. In this regard, it would be profitable to state the law laid down in so and so. So, according to the learned single, 21. In the present case, the state respondents have not been able to show this court under what source of power the state respondents number 6 has been absorbed into the Mizoram Health Services, as there is nothing in the Mizoram Health Service Rules 2009 by which power has been given to the state respondent to absorb a person into grade 1 of the Mizoram Health Service. The state respondents will have to take steps for repatriation of the respondent number 6 to the parent department that is respondent 7, if his term is of deputation is over or unless his period of deputation is extended as per law. So the source of power I have to show, Lordship. Again, there are two sources of power. One is the relaxation power under Rule 30. That is one power. The other is Article 162. I have judgments to that effect, but Lordship will kindly give me some other date. I have gone through the judgments also. So it is going to be 1 o'clock number 1, and second up, I have some difficulty today. I'll place the specifically whatever Lordship has asked, I can give the citations also. I have gone through the judgment. Straightway, that is helping me. Residuary powers of the state has been given by the Supreme Court. That in this situation, in case of absorption, when there is no specific law relating to the absorption in their service rules, in that case, 162 can be invoked. Straightway, Lordship, direct judgment on this point.
7th May.
7th May. Highly obliged, Lordship.
18 minutes.
I have a serious matter also in the list, Lordship, that may also be adjourned today.
Which one?
Today. 18 to 26.
My lord, I have appeared for the appealants. I have appeared for the appealants. Already on the last occasion.
No, they can, Lordship, hear their side, Lordship. My response may be on next Wednesday, Lordship.
No. No.
We have put a respondent.
When?
Let it be after on 7th of May, Lordship.
7th of May.
Or 23rd of April.
April, man.
25th.
25th of April.
Highly obliged, Lordship.
There is an interim order, maybe continued.
Order if you need to continue. Is it limited?
Yes, yes. All the
Continue till next date.
Still.
Yes.
Deeply obliged.
Item 13 and 14.
My lord, I appear in item number 13. I appear for the petitioner.
Fine.
Your Lordship, I'm appearing for the petitioner in item number 14 virtually, Your Lordships.
Yes.
Yes.
My lord, item number 13. My lord, we have challenged the constitutional validity of Article 11 of Schedule 1 of Assam Court Fees Amendment Act 1947, my lord, whereby and whereunder 7% ad valorem court fees has been fixed on probate or letters of administration without being any upper limit. Now, my lord, without fixing any upper limit.
Just a minute, hold down. There is some mention on behalf of the council for the response.
Lordship, I'm appealing for the respondents. But Lordship, today we have received a communication from the Judicial Department, Lordship. Here, Lordship, it's written that the process of considering the matter of ad valorem court fee grant of probate is going on. And along with that, Lordship, as per direction of the Ministry of Law and Justice, Lordship, a process of overhauling the entire fee structure, Lordship, is under consideration under the Court Fee Act, Lordship. Therefore, Lordship, some time may be given, Lordship, because the process is going on, Lordship.
My lord,
Your Lordship,
my lord, let me just say only one thing. My lord, it's a matter of 2018. My lord, this stand has been taken by the learned Advocate General on behalf of the state that they are considering it for a considerable period of time. My lord, my client is 94 years of age. My lord, he is not the beneficiary also. He is just execute the intention of his elder brother.
Your Lordship, in item 14, I happen to be in a similar situation where I happen to be a slightly different situation where I happen to be a beneficiary under a will, but because the valuation of the property is at.
My lord, only one thing, my lord, your lordship has to consider, my lord, the neighboring state, West Bengal, has an upper limit of 50,000 in probate. In Maharashtra, it's 75,000. In Gujarat, it's also 75,000. Rajasthan is also, well, there's a case, Supreme Court has decided from Rajasthan and Karnataka, this reference has already been decided in Ashutananda Setti's case, where
it's
Supreme
1989 judgment.
Yes, my lord.
Where is the Advocate General?
Lordship, he has some difficulty in the second half, Lordship. He was there in the first half.
Otherwise, Lordship may take up the matter on a different day, Lordship, because the department is considering, Lordship.
Department is considering since so many
Yeah,
years.
Lordship, that is there, but Lordship now again, Lordship, the matter.
Either give us assurance that the department is coming out with the concrete proposal.
But Lordship,
By what time?
Lordship, 4 weeks may be granted because
No,
this
that's
thing may
not
take
the
some
4
time,
weeks. No,
Lordship.
we can't grant 4 weeks because earlier also for the same reason you short time and time was granted.
If your lordship permit, my lord, may I indicate your lordship would see order dated 16/8, my lord, where, my lord,
16/8/2023.
my lord.
Yes. Yes, that is there.
My lord, my lord.
Please, just a minute, we are having some, we have raised a query to the council for the respondent. Please wait for that. Yes.
My lord's predecessor, Justice Shah, has asked learned Advocate General one question that can you just tell me how many probate cases filed in Assam because of these stringent provision? Assam is losing revenue. No one is going for probate.
That is altogether another thing, but we are simply, why you are seeking more time, then argue it.
Your Lordship, if your Lordship may permit me.
For this matter, for this reason, madam.
Lordship, in any case, Lordship may take up the matter next week, Lordship, the learned Advocate General will apprise the court, Lordship.
Yes.
Lordship, on Wednesday.
Okay, learned, we are fixing it in the next week.
Lordship.
My lord.
Your Lordship, my only request, Your Lordship, in item 14 is.
Yes, what is your request?
Your Lordship, if on the if on the very next date, Your Lordship, if the government comes and says that they still need more time, my humble submission is that Your Lordships may please kindly hear the matter finally and decide the issue.
So what we have said just now to the council for the respondent.
Much obliged. Much
Just now to the council for the respondent.
Obliged, Your Lordship, obliged.
Ms. So-and-so, appearing for the respondent has submitted that Mr. D. Sekia, the Advocate General, is having some difficulty in arguing the matter today. Place this matter on 21st of March.
Much obliged.
Deeply
obliged, Your Lordships.
Item 15.
May please. May please, Your Lordship. Lordship, may the the matter be fixed after a week, Lordship, because we start. The matter will be adjourned for the day, Lordship, because
4 weeks.
4 weeks.
For hearing item 17.
Lord, in this case, I'm appearing for the respondent, my lord.
Who is for the appellant?
It's not an appeal, my lord, it's a writ petition against an order of CAT. Now, my lord, in the writ petition is filed challenging the order of CAT whereby his claim for promotion was denied. Now, in the meantime, my lord.
On account of FIR, one FIR.
Yes, my lord. Now, in the meantime, that FIR was resulted in his conviction and he has been convicted and sentenced to undergo 5 years RI. And then pursuant to that order, he has been compulsorily retired from service. So as on date, my lord, he is not even in service of railways.
Yes.
Lordship, my senior is leg on in another one.
Only your senior, if he has already been convicted and voluntarily compulsory retired.
And the order of punishment, retiring him compulsorily, has not been challenged, my lord.
Nowhere.
Nowhere, my lord. He has not even filed any order, my lord, in any application before CAT.
No relief can be done. Order defeat कर लेते तब तक आ जाएगा.
Yeah.
And my lord, we have
Writ petition is filed by the petitioner challenging the order dated.
Judgment and order dated 12/4/2019.
12/4/2000 judgment and order dated 12/4/2019 passed by the Central Administrative Tribunal Guwahati bench, whereby the OA filed on behalf of the petitioner has been dismissed. Full stop. Essentially, the petitioner has approached. Yes, it has become infectious now.
Not many.
That person has already been convicted
Give me 2 minutes.
and sentenced for 5 years. He has already been compulsory retired from the services. What remains
Lordship,
then?
give me just 2 minutes, my lord. Kindly allow me to make my case as I'm running to this section. I was in a different court.
You're
It's
coming
not
from-
infectious.
So you were on jogging.
Sorry, that I'm coming. Rushing from a different court, my lord. That is why. Sorry, my lord. I'm extremely sorry.
Yes. Take your own time, take your own time.
You want some water, Mr. Shamu?
Well,
Want some water?
it's this. I'm obliged, my lord. Well, I've just forwarded a written argument for my assistance, actually.
Your assistant.
It may help your lordship also.
Mr. Chamua, please respond to the query.
Yes,
You can't say that wait till I finish. The query is very simple. Your client's grievance was that he was denied promotion due to pendency of an FIR. That prayer has been declined by the learned CAT, right? You prefer the writ petition assailing that order. In the meantime, Mr. Chakravarti submits that the FIR has led to registration of a case, and in the trial, your client has been convicted for 5 years. That apart, he has already been retired compulsory from service, and that order of retirement from service on compulsory basis is not under challenge. Is that correct or not?
That's correct.
It's correct.
Correct. Now,
If it is correct, you want this court to issue a direction that your client should be promoted?
no.
Then what is the relief you're seeking?
No, my lord. My relief I am seeking for. The additional affidavit filed by my friend is incorporating the subsequent events. I am before your lordship challenging the validity of the order, judgment and order passed by the CAT.
Yes.
My lord, the CAT has upheld something which is not supported by law.
Whatever it may be.
No, my lord. I pray for a declaration.
What relief at present we can grant you?
My lord, if I am praying for a relief, which would be, my lord, if lordship pleases, that on 21/3/2017, pending conclusion of a FIR, denial of promotion is illegal.
Okay, then suppose we hold this, that denial of promotion was illegal, then what relief?
Consequences will follow, whatever
What
it may.
consequences will follow?
My lord, if I am,
Your conviction, your compulsory retirement, all will go.
no, nothing.
Then-
I am not on this. I am on this, my lord. If the law supports my case, that the CAT has decided something wrong, then my lord, the lordship, my lord, has to, in my respect.
We are not going to.
No, my lord, appreciate for a while, my lord.
The facts and circumstances of the case.
No, my lord,
No.
my lord will appreciate the dates.
No, it is for your satisfaction that we should give a finding, though no relief can be granted. No, we are not.
No, my
going to
lord,
entertain.
what my respectful submission would be, my lord. Lordship is just going to look into a judgment passed by this honorable Supreme
Whatever
Court.
it may be, Honorable Supreme Court, certainly you have a case for that deserves your writ petition allowed, but in the view of the subsequent development, we are not going to pass any order. That's all.
No, my lord will appreciate one aspect.
Can't be.
No, my lord will appreciate one aspect, my lord.
Yes.
Had I
wrong, had I not been wrongly denied the promotion,
Yes.
then I would have compulsorily
Certainly,
retired.
Suppose you are denied, you were denied by promotion illegally. But despite that, in view of the fact that now you are no more in service, you have compulsorily been retired, whether we can
Then, my
issue
lord,
this direction.
with all respect, my lord, will appreciate, then I would have compulsorily retired from a post which is higher than the post I am now retired.
That's altogether a hypothetical question, sir.
My lord will appreciate
And
that.
you have not challenged that compulsory retirement order, then what remains?
My lord, tomorrow if I am acquitted by this honor, got a pending, appeal is pending.
That law is altogether different. Even though acquittal doesn't
No, my lord,
mean that you are, you have to be reinstated in the service.
my lord, looking into the affidavit that has been filed by the department now, which is inclusive of the facts and figures, which is subsequent development. That subsequent development, in my respectful submission, my lord, would not have any bearings on the decision which were taken on 21/3/2017. On 21/3/2017, the facts and figures were different, my lord.
Mr. Chamua, sorry, sir. Mr. Chamua, advance submissions as a lawyer is expected to do. You know the issues. This is not live anymore. We can't set aside the order when we can't give a direction. Your client cannot be, see, promotion is not an order of the court. The court can only order consideration. That consideration cannot happen today because your client is not in service. So hypothetically, you can't turn back the clock and do an academic exercise. That is why no relief can be granted, and that's why we're not. If you would have challenged the order of compulsory retirement, still you would have had some lease of life, something to argue. But you have not even challenged that. You accepted the order of compulsory retirement.
But if lordship refuses to interfere with the CAT's order, then my lord, in my respectful submission, that a wrong order will stand, my lord. It will set a bad precedent. My lord will just.
CAT's order is not a precedent.
No, my lord will see, my lord, just one judgment, my lord, that your lordship may consider.
Sorry, sir, please. Now, please, don't insist us. Yes. The petitioner has approached the cat Guwahati, aggrieved by the action of the respondents of denying promotion to him on the next promotional post. Full stop.
On the ground of pendency of affair.
On the ground of pendency of, and on the ground of registration of an FIR against him. Full stop. Para. Learned counsel for the respondent has informed that in the said FIR, the petitioner was put to trial and the competent criminal court has convicted and sentenced the petitioner.
White order dated 27/2019. Get it.
Order dated
20/07/2019.
20th of July 2019. It is further submitted that pursuant to the said conviction order, the petitioner was compulsorily retired from the service
on 18/12/2019. By order dated 18/12/2019.
And the said order of compulsory retirement of the petitioner has not been challenged by him till date. Full stop. Taking into consideration the fact that the petitioner has already been compulsorily retired and the said order is has not been challenged by the petitioner, we are of the view that this writ petition challenging the validity of the impugned order passed by the court is by the cat Guwahati is infectious for all the purposes. Is infectious, hence dismissed as infectious.
No adjudication. In as much as no relief can be granted to it.
Infectious as much as no relief can be granted to the petitioner at this stage. Hence, petition is dismissed as infectious.
Item 27.
Should may I pray for a Passover also?
Passover is a fishery matter.
We don't have any other.
This is a fishery matter, my lord.
Next
It's a-
week, Karna, next
Is for 7 years, the learned single judge has set aside my learned friend's client's fishery, the settlement was given. So now they are continuing. As far as some urgency is there, if your lordship wishes the next week, absolutely no problem.
next week,
Some urgency is there. Yes, sir.
next week.
Next. Can your lordship fix a date if
I do, your
not
lordship.
inconvenient?
25th. The 21st of March.
Lordship, 24th, there's some inconvenience, 22nd is.
20th.
I think it's a holiday.
21st.
Lordship, 22nd, your lordship.
Okay, 22nd.
Lordship.
Item 30.
May I please, your lordship? Senior counsel, Mr. B.C. Das will argue in this matter, lordship. And he is item number 30, lordship.
Lordship, this matter has become.
Somebody has circulated adjournment slip.
Lordship, we have objection, we
Lordship.
have raised objection because settlement is year 4th June 2024, Lordship. And as per our submission, Lordship, this matter has become infectious because they have challenged the clause that before during pendency of this writ appeal, Lordship, they have challenged the clause that before the learned single judge and learned single judge has dismissed that petition.
Lordship,
Therefore, infectious.
Yes, Lordship.
How it is infectious?
Because they have raised this point of clause 10 of in this writ
Your
appeal.
lordship, senior
But
counsel, Mr. B.C. Das will argue in this matter, lordship, but now he is
And
physically ill, lordship.
While setting aside
So
the
matter may be
settlement
adjourned
order,
for weeks,
while
lordship.
setting aside the settlement order, learned single judge has observed that since the matter is for 1 year, Lordship, settlement year.
22nd.
Lordship, may fix the matter on 19, Lordship.
22nd. 22nd. Then counsel, preparing for the appellant, has submitted that Mr. B.C. Das,
Yes, lordship.
Mr. B.C. Das is not in town. And therefore,
Is not well. Is not well.
he is not in town.
Intimate of past earlier shall
Is
continue.
is not well or not in town?
Not well, lordship.
Not well.
Yes, lordship.
Therefore, matter may be adjourned. List this matter on 22nd of March.
Interim order passed earlier shall
Interim
continue.
order, if any, to be continued till next date.
Deeply obliged, lordship.
30.